Well, folks, like I anticipated, there was a filing today, two documents, 196 and 197 in the Colborn versus Netflix. This is the first, 196. Uh, Plaintiff's reply brief in support of motion for sanctions. Introduction. Plaintiff filed a motion for sanctions, requested the court invoke inherent authority based on culmination of discovery delays and foot dragging by the defendant Netflix Incorporated. Netflix's response to the motion is long excuses and finger pointing, but short on anything that would give reason to believe that Netflix intends to do better going forward. To the contrary, Netflix insists that the conduct with respect to discovery has been appropriate or even exemplary, despite the fact that plaintiffs has had to file two prior motions to obtain compliance with discovery obligations plaintiff plainly set forth in the rules of civil procedure. Further, responses to discovery requests that were pending were obviously hasted by this motion and were concluded later than promised by counsel to meet and confer. Ultimately, Netflix arguments lack sincerity. Plaintiffs respectfully request that the court grant his motion and issue appropriate sanctions. Argument. For the reason explained in plaintiff's initial brief that those set forth below, plaintiffs respectfully request that the court issue appropriate sanctions based on Netflix's pattern of discovery delays and obstruction. Plaintiff's motion requested that the court exercise its inherent authority. In Netflix's response, it badly asserts, with no citation of plaintiff's motion or brief, that the plaintiff seeks sanctions of Rule 37, document 194 on page 20. Plaintiff's motion and brief both plainly state that the plaintiff requested that the court exercise its inherent authority to issue sanctions. Docket 190, page 1, and page 1516. Plaintiff cited Rule 37 cases, because courts also frequently issue sanctions under Rule 37 to accelerate sanctions that have been found to be proportional to patterns discovery delay. However, as Netflix counsel is too sophisticated to have misunderstood plaintiff's citation to those cases, examples of proportional sanctions in no way altered expressly stated basis cited for plaintiff's motion. Plaintiff requests that the court ignore Netflix's attempt to put words in plaintiff's mouth regarding the basis of sanctions the plaintiff requests. A sanction is appropriate. Netflix characterizes itself as a model, diligent, and respect to discovery in the case. The narrative by Netflix does not ring true, and for good reason. The record is the contrary. Unlike most litigations, Netflix had to order participate in Rule 26 conference, docket 134. Although Netflix claims that it properly objected in responding to any discovery request thereafter, Netflix document 194, page 15, the one thing is to assert the specific substantive objection to proportions of discovery, as Rule 26 contemplates, and another thing to arrogate to oneself the right unintentionally, unliterally, declare the state of discovery, as Netflix did. Audio recording, court commission comments regarding defendant's literal self-imposed state of discovery. Further, Netflix portrays that the fact that Judge Pepper was not micromanaging the case amid her other responsibilities as chief judge as somehow endorsement of its decision to declare itself immune from discovery obligations during a period when, in essence, the teacher wasn't looking. While Netflix also contends that it would have been entitled to stay or discovery pending its motions to dismiss, and it requested one and never sought court approval for any state of discovery. Moreover, it seems highly unlikely that outside of a briefing on the second motion to dismiss, the court would have granted Netflix a stay of discovery that extended indefinitely. Given the motion more closely resembled a motion summary judgment and that the motion was only asserted through a loophole in the Seventh Circuit case law that has not yet foreclosed serial motions to dismiss, unlike other circuits. See plaintiff's brief response, Netflix motion to dismiss Second Amendment complaint, docket 131, page 15. There is no way to explain away that the fact that Netflix spurned the rules civil procedure by refusing to participate in Rule 26 conference absent of the court order by declaring that they would refuse to respond to any discovery until resolution of the motion to dismiss. Netflix conduct prior to discussion decisions on the motion to dismiss provides context to show that Netflix subsequent delay in producing documents after the court's decision is not a one-off. Rather, Netflix is acting in accordance with previous established pattern delay and obstruction. It is not taken to the heart that the court's message that defendants should turn around responses promptly following resolution of the motions to dismiss. Docket 169. I'm going to go over all these documents one day. I'm going to start with the first one and go all the way through them. As the Seventh Circuit has explained, a litigant and not entitled expert shot across the bow before sanctions are issued to penalize abusive discovery tactics. But here, the record demonstrates that Netflix has already received what it should have understood as warnings by the court. This first occurred when Judge Pepper compelled defendants to participate in Rule 26 conference without awaiting a response from defendants to plaintiff's motion for the relief. The second occurred when the court granted in part plaintiff's motion to compel outstanding discovery, including initial disclosures, and the defendants had refused to provide, and it indicated that the defendants would need to provide discovery promptly if the court denied any of their motions to dismiss. Docket 169. Despite the unequivocal messages, Netflix persisted in its "well, give it to you when we want to" and our terms, and to the respective plaintiff discovery requests after the denial of the motion to dismiss. Netflix held up a document production based in protective order that could have been proposed prior to the time that it was supposed to respond. Although Netflix attempts to blame plaintiff for a month that passed after a forward of the draft protective order, the issue is red herring. Plaintiff's counsel requested that Netflix provide non-confidential documents pending entry to protective order. Supplemental declaration on April Roxy Baker. Netflix never responded to the request. Irrespective of the purported need for protective order, Netflix provided no documents to plaintiff at the time that it was using protective order as an excuse for delay. This is true even though the eventual production included some documents that are apparently public filings in the United States Copyright Office. Even after a protective order was issued, plaintiff's counsel had subsequently inquired when documents would be forthcoming, only to be met with yet another obstacle to production in the form of ESI protocol that Netflix insisted that it had prepared, reviewed, and negotiated before any documents could be produced. Declaration in April, Roxy Baker filed December 24, 2021. The needed blanket advance agreement regarding ESI had denied the joint discovery report. Netflix only dropped the demand at the meet and conference September 16, 2021. At the conference, contrary to Netflix's characterization of it, plaintiff's counsel did not manifest acceptance of Netflix's description of how it intended to produce documents. At the point, allegedly on a rolling basis, through mid-October, now 2 weeks ago, Superior Baker counsel attended the conference, made clear that Attorney Burnett, who is plaintiff's lead counsel, was not happy, to put it mildly, but the manner in which discovery had been handled by the defendants, and the Attorney Burnett would have to make a decision how to proceed in light of defendants. 3. Plaintiff has not requested an ultimate sanction, but rather a proportional sanction. Netflix also attempts to downplay its conduct, arguing that it has not done anything as irregular as others who have been sanctioned with dismissal or default. Plaintiff respectfully submits that the calculating manner in which Netflix had delayed discovery in the case is particularly offensive to the discovery process that is supposed to function without the need for court oversight. Plaintiffs had argued to file the motions for what should have been automatic under the federal rules. After 2 motions and orders against Netflix in nomination of the court, Netflix still threw up obstacles designed to delay its current production, the latest of which was only retracted after it became clear that the motion was imminent. And if Netflix had expended half as much energy to respond to the good faith discovery as it has formulating technical arguments designed to thwart plaintiffs' efforts to obtain discovery, discovery process may nearly complete now. Netflix cannot credibly claim to be surprised, blindsided, that the tactics again wore too thin and tolerated. Nonetheless, plaintiffs had not requested ultimate sanctions and described in opinions that Netflix attempts to distinguish. Rather, plaintiffs request and other precluding Netflix from contesting actual malice. Plaintiffs respectfully submits that the order would permit the parties to move forward with discovery on other issues in the case and the time remained in discovery. Alternatively, plaintiff requested some sanction in the court may be appropriate under the circumstances. Netflix's response makes misrepresentations of the court that are concerning in their own right. It is zeal to spin the facts in their favor. Netflix oversteps the boundaries of candor. For example, Netflix claims that it did not misdirect plaintiff's counsel by using pandemic as excuse to defer response to discovery requests seeking raw footage of the Avery child, and then, months later, only after plaintiff counsel revisited the topic, disclosing that it did not have the raw footage anyway. Netflix response to docket 194, page 14. In a carefully crafted explanation, Netflix asserts that at the time, Netflix counsel represented all defendants, so there was, according to Netflix counsel, nothing wrong with Netflix claiming that the discovery response should be delayed for public health considerations, while failing to flag that the fact that the Netflix did not have responsive materials, because apparently the other defendants counsel represented at the time might have them. Clearing flaw in Netflix after the fact that justification in the discovery requests for the raw footage were pending at the time, specifically directed to Netflix only. Declaration of April Rockseed Baker, filed September 24th, 2021, docket 192, page 2, is only after Netflix disclosed that it had not have raw footage months later. The plaintiff served a separate request for the footage of the other defendants, whereby at the time were represented by a separate counsel. Therefore, counsel's joint representation of others defending at the time request was addressed to Netflix, gave counsel no reason to respond, as Netflix and materials had simply not produced due to the pandemic. In a similar vein, in a letter threatening plaintiff to withdraw the sanctions motion, Netflix feigned ignorance of the federal rule that extends deadlines after service by mail in order to contend. Baselessly, the plaintiff's written response to the plaintiff's discovery were ultimately or untimely and objections were waived. Declaration, Lita Walker, docket 195. A point that assertion without comment when confronted with response citing the rule. Baker, Exhibit 4, if the rule did not extend time in instances for service by mail, the Netflix written response to plaintiff's discovery request would have been ultimately Therefore, Netflix was aware of the rule it pretended otherwise in the letter to plaintiff's counsel. It is sadly apparent that even the response to plaintiff's motion addressed to Netflix gamermanship. Netflix regards gamemanship as simply part of the game, even after it has twice been ordered to comply with discovery obligation in the case. Unless an appropriate sanction is imposed, plaintiff fears, based on ample experience, the plaintiff will simply meet more same resistance in the time remaining to discovery. Plaintiff has prejudiced by the delays in discovery before and after the decisions in the motion to dismiss. When Netflix claims there is no harm, no foul, because approximately 6 months of the discovery period remain under the scheduling order, there is no question that the plaintiff will be time crunched by Netflix tactics and effect to undoubtedly by design rather by accident. Netflix response to discovery requests seeking the information identified in Netflix June 2021 initial disclosures, which is due July 2021. Netflix represents that it completed the production relating to those disclosures yesterday. Therefore, it has taken from a June service of plaintiff's request to late October for plaintiff to obtain responses to the documents that Netflix considers first legitimate document request directed to it. With more than 4-month response period as norm in Netflix view, which was in case, doubtless, expedited by the plaintiff's motion, plaintiff can realistically hope for only one more opportunity for a document discovery before the close of the discovery period. Yet, Those documents are necessary to meaningfully dispose defendant's witnesses. Further, Netflix again discounts the delays in introduction while refusing to respond to any discovery for nearly 2 years. During Netflix's announced refusal to cooperate with discovery, it was pointless at plaintiffs to attempt to serve further discovery. Plaintiffs' counsel could not undertake the unusual analysis of discovery responses necessary to formulate further or more refined requests. Because Netflix made it clear that the plaintiff could expect no responses until plaintiff filed a motion to compel, at the minimum, Netflix has deprived plaintiff of the opportunity to conduct discovery in order of plaintiff's choosing, which plaintiff normally would have ruled number 26. Netflix also points to the summary judgment deadline, alleged proof that the plaintiff faces an amendment motion, when it is obvious the deadline does not preclude defendants from filing motions before the date. Netflix should be rewarded for discovery delays. Netflix also argues that it should be awarded attorney fees in responding to plaintiff's motion, but it has not filed a motion seeking these fees. Therefore, a request would be procedurally inappropriate even if it had any merit. Netflix also references Rule 37, but as the plaintiff explained above, plaintiff did not bring in motion Rule 37. Substantially, Netflix requests for fees are remarkable for the lack of self-insight. Netflix unresponsibly and vexatiously multiplied these proceedings with serial motions to dismiss by requesting resort of court to obtain compliance with multiple discovery rules. As explained above, plaintiff has twice prior to this motion had to file motions to require Netflix to comply with the basic discovery obligations that are imposed by rules of civil procedure. In neither case did plaintiff make an express request for attorney fees, despite the time and effort requested to prepare those motions to respond to Netflix arguments in opposition. Throughout the course of this case, plaintiff's counsel had expended for more time attempting to pursue discovery and filing motions to secure cooperation that should be necessary in federal court proceeding. It defies credibly that Netflix would have suggested that it should now also be rewarded for its poor behavior with an award for attorney fees. Needless to say, plaintiff respectfully requests that the court deny Netflix's request. Much like Netflix communications related to discovery throughout the case, Netflix responds to brief launching filed accusation towards plaintiff, but the record believes that the obvious, which Netflix has been making discovery unnecessarily difficult and protracted through the conscious effort and continues to do so even after now the motion to dismiss. The court signed prior to the decision discovery should move forward promptly. Therefore, after too much time in this case has already been lost in discovery. For the plaintiffs, responsibly hope for better days ahead, only to wind up the court's doorstep weeks before the deadline for discovery to be completed. Unfortunately, after prior orders and participate in provided discovery, followed by obviously manufactured delays, it does not appear to be likely that Netflix would change its ways forward unless it receives a stronger and more direct message this time around. Plaintiff respectfully requested the court enter ordering precluding Netflix from contesting actual malice for purpose of these proceedings, or such sanction the court may deem appropriate under these circumstances. Alright, that's the 196 document in the case. Now I'm going to go to the declaration order. Alright, this is 197 document filed in this case, which started in 2018. April Roxy Baker declared under penalty of perjury as follows. I am one of the attorneys plaintiff in above caption action. Attached to Exhibit 1 is a true and correct copy of an email message that I sent to counsel for the defendants, including Lita Walker, counsel for Netflix Incorporated, on July 28, 2021. To my knowledge, never received a response specific to my request for production of non-confidential documents. Attached to Exhibit 2 is a true and correct copy of an email message that I sent to Lita Walker on June 24, 2021. In early July through mid-July of this year, I was also in communication with the defendant's counsel regarding a supplemental joint discovery report the defendants proposed. Attached to Exhibit 3, true and correct copies of a portion exhibit document that was contained in the first document production by Netflix Incorporated. on September 17, 2021. Attached is Group Exhibit 4 and a true correct copy of the email exchange that I had with Lita Walker in response to her October 7, 2021 correspondence. During the September 16, 2020 meet and confer with the Defendant's Counsel, I did not indicate or manifest acceptance of the terms, timing, and production that Netflix alternately informed me would be following. Rather, I stated at the outset of the call that they were unfortunately unlikely to make progress unless defendants indicated they would provide documents a week or so. After Ms. Walker described Netflix's timetable for production, I indicated to counsel on the call that I would have to talk to Attorney Burnett, lead counsel for the plaintiff, to determine whether he would accept the proposal and resolution of discovery dispute. Attorney Walker demonstrated understanding of this, stating something to the effect of, "You talked to George. Attorney Burnett did not find Netflix's proposed timetable agreeable. Further discussion would have been further futile after this point." Attorney Walker's statement that she offered to provide an extension to plaintiff to respond to discovery response served by Netflix Incorporated on plaintiff is not true, to the extent that they may be contending that the offered an unconditional extension to me that was there for the asking. During the September 16, 2021 call, I asked Ms. Walker if she would extend the deadline for a response given to Netflix after it produced the document the plaintiff requested in June. Ms. Walker responded that she would consider, emphasizing the word, providing an extension if we provided a specific reason for extension. Otherwise, she firmly indicated Netflix would expert time me with in response to discovery. To my recollection and understanding, disagreed with the suggestion that timing of Netflix production alone be justifiable reason for extension deadline. Respond to Netflix discovery dated this day, 29th. Now we got the emails that are attached to this. Lita, Kevin, James. Based on the court's comments today, it appears that something more substantive will have to be submitted before the judge will agree to enter the protective order. I assume that you're likely preparing something for the court in that regard. In the meantime, in the interest of avoiding further delay, we would like to move forward with respect to the responsive discovery materials that would not be designated as confidential under a protective order when entered. Please confirm that these materials are not claimed to be confidential and can be forwarded while we sort out the protective order. Respectively, thanks very much, April. All right, from April to Matthew Kelly. Normally, I would have sent them by email as well, but I've been inundated with matters that have waited while I was out of the office for essentially 3 weeks through my mother's hospitalization, transfer to hospice, and passing. In addition, I have co-workers here asking me to help them with urgent matters with deadline. And I'm still dealing with issues that I have addressed from my mother's final affairs. I have very little staff help available to me, as well as pandemic or no, unfortunately. So I can assure you that it was simply a matter that I literally had to get those in envelopes and mail on the way out the door. I had no opportunity to go down to the one scanner I can use on the lower level before I could another obligation that day. Then had to assist with our urgent briefing deadline all day the following day and have prepared oral argument out of town yesterday since then. Certainly no offense was intended by sending them by email. In calmer times, I will of course endeavor to send documents by email as well. Hi April, I believe you mailed the third set of discovery requests in Colborn matter on June 16th, but I received them today. Our office is still operating under pandemic protocols, which means we have skeleton staff on site. And receipt of the mail sent the old-fashioned way is often delayed. It's not too much trouble to send by email as well. I would appreciate it. We are happy to extend the same courtesy to you, of course. Certificate of recordation. This certifies that the attached document was recorded on a date, blah, 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 blah. And copyright office, subject chain. I don't know what the hell this is. Oh. Oh, this is synthesis films and making a murder. So they got involved because this is November 16, 2015. Interesting. I cannot respond to your entire correspondence immediately, but suffice is to say I disagree with virtually all of it, including the way that you characterized our conversation on December 17th. However, to clarify as initial matter, your discovery requests were only validly served on us by mail because we had not consented to service by email, as you acknowledged in your current received message. Therefore, 3 days are added to the response period under Federal Rule of Civil Procedure. Accordingly, response are timely. April, thanks for your email. Please let me know when you can respond substantially to the letter whether you will withdraw the motion for sanctions. I cannot respond to the entire correspondence immediately, but suffice to say that I disagree with virtually of all of it, including the way you characterized our conversation on December 16th. However, to clarify as initial matter, your discovery requests were only validly served on us by mail because we had non-consented to serve by mail, as acknowledged in a recent message. Therefore, 3 days are added to response, blah, 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 blah. And that's all we have. So, if you guys got any questions, I'll stick around for a little bit. Otherwise, I got something I need to do. It's like a chess game, just like with Stephen's case. I just don't understand why Colborn even took out this lawsuit if he didn't have the proper documentation to prove his case. So, I don't know. I'm assuming we'll get a response back by next Friday, but who knows? It may take 2 weeks. But until any information comes out, I'll see y'all next time.